All right. Well, good afternoon, everyone. Thank you for joining us today. This is the first of a three-part series, and we're going to talk about the anatomy of a board investigation. The future series will talk about, what you do in response, how you actually craft a response to the board, some helpful tips if you're going to go before the board for a hearing, and the last part will be obviously some additional advice on, the consent order, what the impact is on your practice, on your license, because all of this is interconnected. The reason we wanted to start off with a anatomy of a board investigation presentation is simply because we want to demystify some of this, and we also want to correct some frequently encountered errors that we see, some misconceptions of what the board is and isn't, how to interact with them. So this is a good primer. If you've never had to deal with the board before, that's great. I hope that this is purely informational for you and you don't have to deal with them. If you're currently dealing with the board or have in the past, you'll understand that there's quite a bit that goes into responding to the board. It's not and should not be taken as an informal process. And that's why we do a lot of what we do. As a initial disclaimer, nothing of what we do here is actually, legal advice. We can't give legal advice in a group setting like this. If you're interested or have a current issue with the board, please feel free to reach out to us offline, and we'll be more than happy to discuss with you how we can be of any assistance. I understand that from this interaction we're about to have here that we may not be the type of attorneys that you want to sit across from at a conference room. However, as a boutique healthcare law firm with over 20 years of experience in the field, we have in excess of 40 healthcare attorneys that work at Frier Levitt. We are national in scope. And although Alan and I may not be your favorite people and you may not want to be talking to us because it usually means you're under some type of investigation, we have plenty of other partners and attorneys here who deal with more fun aspects of medicine, such as expanding your practice, signing on with vendors, creating a super group, and a lot of other transactional issues. So if you ever need any help on any healthcare issue, I can guarantee you that we have a healthcare attorney with specific area expertise. My name is Guillermo Beades. I am a partner here in the Healthcare Litigation Department. I co-chair the Insurance Defense Department with Daniel Frier, one of our co-founding members. I regularly present on issues concerning board discipline, board investigations, and also overpayment demands and civil litigation that relates specifically to allegations of fraud, waste, and abuse in a billing setting. My co-presenter today is Alan Blankstein, who's in our healthcare group. He used to be, prior to this, Deputy Attorney General at the Board of Medical Examiners. You'll learn during this presentation about what each DAG does at the board. Some of them are prosecutorial, some of them provide advice to the board. Alan was one of those attorneys who was prosecuting, so he has a couple of bits of practical advice and some war stories that he'll be sharing with you during our presentation here today. Our goal is, again, to demystify this board procedure, what happens, what they can and can't do, what their limitations are, and above all, have you prepared in case you ever do have to deal with the Board of Medical Examiners. So when we're talking about who is the Board of Medical Examiners, what is this nebulous, unknown entity, I'm going to turn it over to one of their former employees and my colleague and professional, Alan Blankstein, who's going to take you through the New Jersey Professional Licensing Boards.
All right, thank you, Guillermo. Hello, everybody. As Guillermo said, my name is Alan Blankstein. I was a former Deputy Attorney General. I've been at Frier Levitt about 4.5 years now on the good side. So the Board of Medical Examiners is one of 49 licensing boards found under the umbrella of the New Jersey Consumer Affairs Division. It's made up of 21 members, all which are appointed by the governor. They don't always have a full board, but right now they actually do have, I believe, the entire board is full except for one member. Disciplinary actions are enforced by the Attorney General's office, meaning that if they receive a complaint against a physician, if they conduct an internal investigation, if they do make any kind of an action against a physician in any way, the actual enforcement of that action will be done by the Attorney General's office itself. The Board of Medical Examiners does not have any of its own legal staff or enforcement mechanism. It's more or less sits as a court of judgment over doctors, as well as a regulatory agency and investigatory agency. As Guillermo mentioned, the deputies attorney general are the ones who do the enforcement of these actions. There's two types. There's counseling and there's prosecution. Counseling in the Board of Medical Examiners context, they have an attorney who sits and provides them legal advice about what they can and can't do during the course of an investigation, what they can and can't do when discussing matters with a physician. And if they get to a point where they're actually handing down discipline, either after hearing or less so with a negotiated consent order, but typically with a hearing, the counseling deputy will actually write the order, write the opinion for the board. The prosecution deputies act as any kind of a prosecuting attorney would act. They lead the investigations. They handle the trials before the board, any motions before the board. They will conduct any negotiations with a physician who is a target of an investigation or their attorney, and they will be the ones that negotiate the consent orders, which are more or less akin to a plea agreement with the Board of Medical Examiners. So investigations generally, as I noted, the investigations themselves are handled by or spearheaded by the deputies attorney general. However, the board uses investigators from the Enforcement Bureau within the Division of Consumer Affairs. These are the same investigators that handle any consumer affairs board investigation. They have very broad powers to investigate, which we'll discuss later, but they also will make doctors feel so they have even broader powers to conduct these investigations. So it's very important that any physician understands what their rights are when an investigator comes knocking at their door, if that is to happen. We've noticed a couple of trends in the last few years now that COVID has ended. They have started to begin really investigating diversion and indiscriminate prescribing cases, not quite to the level they were doing in, say, 2014, 2015, but it is significantly higher than it had been over the last probably 6 or 7 years. That has been a number of our cases lately have been over diversion or really indiscriminate prescribing. Obviously, physician misconduct, anytime there's any kind of alleged misconduct, sexual misconduct, physical misconduct, something that where a patient feels that they need to complain about the way that a physician interacted with them, they investigate that. And then inappropriate billing, depending on the severity and the allegations involved, this can either be secondary to other allegations that they're handling, or sometimes if it's very severe or there's real fraud involved that can't be handled by any other entity, they will involve themselves in this and can, in fact, issue discipline if this is something that they discover. So, as I said, there is broad powers of the board to investigate physicians. Much of this broad power comes from the duty to cooperate that is written into New Jersey law 1345C 1.2. Essentially, board members have to, anyone with a medical license in the state of New Jersey or any license under any of these various boards has a duty to cooperate with the board in an investigation. This means that you don't have the same privileges and rights to self-incrimination that you normally would. You wouldn't have the same rights against an unlawful search and seizure. If they ask you a question, you have to answer. If they ask you to provide something, you have to provide it. If you do not, it can give rise to its own grounds for discipline. And that's what makes these types of investigations very difficult to really understand unless you have a lot of experience dealing with them. As I said, you don't have the usual privileges like your Fifth Amendment. Meaning you can't assert your Fifth Amendment right not to incriminate yourself in a board investigation. You still obviously have your Fifth Amendment right not to incriminate yourself in a criminal investigation, but it can get a little tricky because if you assert that right to the board, it's still a failure to cooperate. They can make adverse inferences. It's something where you would want competent legal counsel to weigh all of that or help you weigh all of that when making that decision. You have limited appeal rights because this isn't a court. This is a regulatory matter. Obviously, if there's a final decision, you can appeal to a court, but it doesn't work itself through the way that a case normally would. The board has plenary power, meaning that it can investigate both whatever the issue that it is attempting to investigate. If there's a complaint received or there's a concern about prescribing, it can investigate that, but it can also investigate everything in your practice. If they come and say, we think you're indiscriminately prescribing, and they find that, your record keeping is below standard, then they can investigate that as well. There's no limits on what they can do at any one time. And then fee shifting, if you lose, and oftentimes, especially more recently, if you even agree to a consent order, if you make it very difficult for the board, they can and will shift both their attorney's fees onto you as well as any investigatory fees. So it can get very expensive.
All right. So thank you, Alan. So we'll talk a little bit about how boards actually initiate an investigation, because some of you maybe in the past have maybe received a letter from the board saying that there's a patient complaint. That's the most common. Typically, their letter will say, we have one version of the facts. We would like you to answer and respond with your version, with what you believe happened. And they give you 21 days to respond. What the letter doesn't say is that you can always ask for additional time and extra 21 days to respond automatically. So when you receive a letter, and sometimes they might write a letter March 1st, but you're not getting it until March 30th, and you think, oh my goodness, I'm already overdue. Let me rush to get an answer in. It's 21 days from when you received it, and then you get an extra 21 days on top of that. So you have plenty of time to basically sit down, take a breather, get counsel involved, work through this, and it's in your best interest to take your time. It's not in your best interest to rush to respond, because the board is not going to take it either good or bad if you respond quickly or if you respond, with more time. You don't want to respond too late. You want to give them a heads up if you need additional time, but there's no deference or there's no preferential treatment if you respond quickly. There's also no presumption for or against you if you use counsel. That's a frequent question we get. Oh, if I get counsel involved, does that mean that they know that we're guilty? Absolutely not. They appreciate attorneys getting involved, particularly healthcare attorneys who know how to speak to the board and how to present a response to the board, because it is nuanced, as we'll be discussing in future presentations. One thing that we can't stress enough, and this is why we bolded it, it's not because we're yelling at you, but the board will investigate every complaint. There is this misconception out there that the board only reaches out to you with legitimate, hard-hitting complaints. Yes, they investigate very important issues, very lascivious fact patterns, but they also will investigate a complaint over a $40 copay. They'll also investigate a complaint because someone was rude to them in the front desk. It may sound like totally frivolous case. It may sound like something that you should not waste your time with, but unfortunately, as Alan mentioned earlier, you have a duty to cooperate. And we've seen doctors get in trouble more often for not responding or being cavalier in their responses to a preposterous allegation than if they had responded and done an adequate job of addressing the complaint. Not responding or being cavalier about it can get you into more trouble than just answering it straight with an attorney and giving it the importance that it's due, because it's a complaint from the board, not importance because the allegations underlying this complaint have any validity. It's two different standards. They will also analyze the prescription monitoring program data. So if your practice prescribes Schedule II drugs or drugs that are maybe in, a hot topic, in the news, maybe the diabetic drug that is being used for weight loss. Well, the FDA sort of issued an opinion that they don't think that's appropriate, and the manufacturers facing shortages, so they don't want it to be used as a, cosmetic weight loss drug. If your practice is prescribing maybe a lot of that, that's something that the PMP might show up and they might start to question. If you're a pediatric practice and you see a lot of Schedule IIs, they're going to say, well, why is a pediatric practice, prescribing a lot of Schedule IIs? You're always being compared to your peers. So if you're doing something that is outside of the norm, and it's not just prescribing it, it could be you are a primary care provider or you're an orthopedic surgeon, but you are prescribing a lot of foot orthotics, billing the L3000 code a lot. Well, they're going to say that's not really within your scope, so we're going to take a look at what you're doing. That may be more of a payment issue with one of the major payers, private or commercial or public payers, but it's the same basic principle that there's something that they're going to be expecting of you based on your practice area, based on your demographics, based on your qualifications. And then if you do something that's outside of that, or you're an outlier in one way, you're going to get targeted. Hospital and other disciplinary investigations, a lot of times those also lead to board investigations, because what's going to happen is the board is going to get a copy of the National Practitioner Data Bank, anything that gets reported to it, and disciplinary actions by the hospital, settlements for malpractice lawsuits, all of those get reported to med-mal companies, and they will investigate all of them. And by the way, they don't investigate them right away. So you may have a settlement and may need to go before the board 2 or 3 years after your settlement, or you may have some discipline from the hospital, and you may not be called in for another 2 or 3 years. That frequently happens. It's not anything personal. It's just, the workload and the backlog that they have. Pharmacies sometimes refer clients as well that we've had to defend. Criminal arrests and convictions, particularly DUIs. DUIs get reported and usually leads to either a temporary suspension or a referral to the physician assistance program that's run by, or was run up to very recently by Dr. Louis Baxter. They're an organization that will deal with abuse and drug dependence and depression and similar symptoms, but geared only towards providers. And then there are other investigations that will find their way to, a complaint or referral being made to the board. So how does the board contact you? They will forward you the exact complaint that was filed by the patient. Sometimes, and you need to understand this, it may not be from the patient, it may be from a relative, maybe from another doctor that's treating that patient and questions something you have done. They'll forward you a copy of their complaint, and then you have to prepare a narrative response. Now, what we like to do after we get an extension is we'll get the relevant medical records. If this is a patient you've been seeing in your practice for 10 years and you have thousands of pages, they're not looking for 10 years of records. If it's a complaint about a recent date of service, we might want to give that one date of service and 1 or 2 prior ones just to sort of provide some background. But you need to send relevant medical records. If for some reason you can't send them, because maybe you saw this person at a nursing home or a hospital, and that custodian of records is the right person, you need to make it very clear to the board why you can't get those records and who they can direct the request to. To say, I don't have them or I can't get them is not usually enough. There's an art and a science to this.
And I think it's also important to note another recent trend we've been seeing is the board is following up with providers after these patient responses. If they believe that they haven't gotten all the patient records, they're issuing subpoenas for those patient records back to the physician. So you definitely, it is crucial that when you submit this initial response, you submit all patient records. Otherwise, you can see the investigation elevate in scope.
Right. The board may send you one letter and you may send a narrative response, but they will come back with more requests for records, more detailed responses if you did not respond to every allegation in the complaint. Again, if a patient alleges 10 things, your narrative should have 10 responses. You can't pick and choose and triage what you think is most important and disregard what you think is frivolous. You have to keep it consistent. That's part and parcel of what we do, is taking a narrative written by one of our clients and then reorganizing it and putting it and turning it into a medical legal response that we've had very good success with. Subpoenas can also be subpoenas is a demand for records. Let's get that out forward, because sometimes there's some confusion as to what the power of a subpoena really is. It's a request for records that you have to comply with, and in the case of the board, you can receive those either in person or by mail. If it's a civil investigation, a civil lawsuit, criminal lawsuit, there's specific service of a subpoena requirement. The board is a little more loose. Many times we'll be representing a client and they'll just ask us to accept service on their behalf. We do that so that no one disrupts your practice by showing up unannounced and serving you with papers. We do that as a courtesy all the time, but that's subpoenas. You have to usually respond by a given date. However, the Attorney General's office has more power because sometimes they're allowed to go in with a subpoena and get records that same day or inspect your office that same day without previously reaching out to schedule for a time. Alan, do you want to just talk a little bit about what allows the Attorney General's office to do that? And if someone does show up to a practice, what kind of paperwork they can ask for to see?
Sure. So I think it's important to note that the subpoena power for the Attorney General in these administrative matters is very, very, very broad. They can ask for a lot of things. Those include a written response under oath regarding services provided by a licensee, inspecting the premises of any practice or site where the licensed services are performed, examining any record, book, etc., maintained by the licensee, and a few other less relevant provisions within that. So the Attorney General can order a inspection of your office. The investigator needs to have what's called a demand for inspection of the professional premises signed by a Deputy Attorney General when they show up. They can't just show up to your office, say, hey, I'm from the state, let me in. They have to have more than that. It has to be executed under the subpoena power, but that ability to come into your office and inspect it flows from their ability to investigate really anything that could be a problem being done by one of the licensed providers. So there's very broad power to do that. Typically, when they do come for an inspection, they will show up with at least two pieces of paper. One is this demand for inspection of the professional premises, and then another one is typically a subpoena for records. They can't, well, they can come in, inspect your office, take notes, look at various different things in your office. They can't take any records without a subpoena. They also can't just seize your records either. They will have, you'll be able to make copies and forward them to the board. But it is important to note that the subpoena power of the Attorney General is not just to say, here's a demand for records. It's also a demand to inspect your office. There's also a demand to have you give a statement under oath, which we'll cover a little bit later in this presentation.
Thanks, Alan.
Mm-hmm.
And as Alan was just mentioning, office inspections, that's another way the board might make contact with you. Sometimes the first notice you'll have that there may be an issue is a board investigator showing up. Now, there's a certain tact you have to take with them. You can't really just kick them out of your office saying, I'm seeing patients, get out. Depending on the paperwork that they have with them, they might be entitled to inspect the premises. Typically, what we advise our clients is to say, can you please wait here in the waiting room, give us your card. Our clients will call us. We'll get the card of the investigator. We'll get on the phone with the investigator, set up some ground rules. Sometimes the investigator will have a subpoena. The subpoena has to be signed by a deputy attorney general. Alan or I will reach out to the deputy attorney general directly that same morning, let them know we represent the practice, that we don't consent to any statements, that we don't consent to certain things, setting ground rules, and then trying to, if possible, schedule for a different date for the inspection to take place. Sometimes, based on the allegations, I'm going to call them because I don't see it actually happening in practicality, but based on allegations that, for the welfare of and safety of the public, they need to do that inspection that day unannounced, so nothing gets changed, or so that there's integrity in the inspection. Sometimes they will not come back into the day. They have to do the inspection that same day. If that happens, again, we counsel our clients on what to do. We walk them through the process, and if possible, we drive down to the office and we're right there with them to make sure that nothing gets out of line. Investigators will also interview patients a lot of times, and that's just a part of their, and sometimes we understand from our clients that they hear about a board investigation because a patient will tell them, hey, I just had some investigator or someone from the board call me and ask me if I saw you on this date, if you provided this service. It's just for you to be aware that insurance companies do that and the board does that. And then the last is the board may contact you with a letter saying you need to come in for an in-person hearing. There are different hearings there, and I would triage them the way that I have it here on this slide, with the PEC being the least problematic, but it's still an appearance before the board, so you should not go unrepresented. The preliminary evaluation committee hearing is usually made up of two or three board members and a deputy attorney general. Sometimes there are some other non-voting board members or community liaison and other people present at the board, along with a stenographer, because everything is being taken under oath, and some other staff from the board. So it might be 8 or 9 people from the board, and then just the licensee and their attorneys. The scope of that hearing will go into at the next webinar, but generally speaking, they want to know what's happening in your practice, and they want to discuss in more detail any complaints that they receive. The MPRC, that's the Medical Practitioner Review Council, they only bring you in to talk to you about discipline that you've already had, or from a hospital, or a settlement from medical malpractice actions, to see if they should take any additional action against your license. And then the last one is the order to show cause. That is the literal definition of why you have attorneys. It is a very adversarial hearing where you're being called in and told, come in within the next 14 days. This is a specific date and time. Make yourself available. The entire board is there. A number of deputy attorney generals are there as well. And all of them are there to decide whether they're going to suspend your license temporarily. And a temporary suspension of your license is a misnomer, because temporary in board terms can last months or even years. And we've seen that from personal experience.
And Guillermo, just before you go on to the next page, we had mentioned that with the patient complaint, responding to it immediately doesn't get you any favors or anything like that. You can always get an extension. Responding to the demands to show up in person, either a PEC or an MPRC, if you need additional time, if you need to reschedule, whatever it may be, responding to those as soon as possible, just to let them know you've received it. You will be showing up, or you can't. Responding as quickly as possible is very important, because if you wait until the last minute to try and reschedule for whatever reason, they often will not allow you to reschedule. So it's very important you respond to those quickly.
That's true, Alan. And they specifically state also in those letters that the unavailability of your chosen counsel or representative is not reason enough for an adjournment. So it's very important that you retain counsel as soon as possible to make sure that they'll be available to represent you at the hearing. These are not hearings to be taken lightly, and we'll discuss a little later some of the common errors that we see in these issues. Multi-agency investigations, we touched upon that earlier, so I'm just going to go through this one pretty quickly. Essentially, State and federal agencies, a lot of times will investigate alongside of each other, and many times you'll see them even cooperating. We had a case where the DEA was investigating a provider based on allegations that he was indiscriminately prescribing. The board was also investigating at the same time, and during our discovery in that case, we found some pretty blatant and we think unethical conduct where the board was investigator was really acting in a rogue fashion and asking the DEA agent to in turn ask the AUSA to issue grand jury subpoenas so that they can get records faster and just go around the slower board process, where the board investigator was alerting the DEA agent that if they call in the doctor now for a board hearing, the doctor's going to have to claim the fifth because there was a pending criminal investigation, and they'd be able to take his license away for not cooperating with the investigators and answering questions directly. I mean, and that's just the tip of the iceberg. The other emails that we saw between the DEA agent and the board investigator, it really was shocking because we don't expect that. The board is not supposed to be this gotcha type of organization. They're supposed to police their own, issue licenses, and discipline where discipline is needed. They're not a, they're not the Attorney General's office. They're not the AUSA's office. They are a, regulatory body. And every once in a while, you get these types of cases where there's a potential criminal track and a potential board discipline. And in those cases, we generally tend to ask that the board hold off on its investigation until the criminal side is completed. Many times this leads to a conflict. In that case that I was just referring to, the target of their investigation, our client, was pressured into signing a surrender of his CDS license and a surrender of his DEA registration when the DEA and the board showed up to his house and then later took him to his office. And they both had him in the same room for hours together. That's where you have to balance your duty to cooperate with the board with your constitutional rights. Nothing trumps your constitutional rights. And what Alan said earlier is absolutely right. Your Fifth Amendment right against self-incrimination, that trumps everything. But in criminal court, they can't hold that against you. They cannot make an inference that your assertion of a Fifth Amendment right works against you. That's a jury instruction that the judge gives to jurors. In the board, it works the opposite. Go ahead. We don't want you to self-incriminate. But at the same time, we can make an adverse inference because of the licensing issue.
Right.
So,
and it's important to note in that context too that they not only can they will make that adverse inference, they will conduct the hearing with the purpose of getting that adverse inference on the record. So it is a very serious decision that needs to be made if that ever comes up.
Yeah. So before we turn it over to the next series of slides on the limits of the board investigator's authority, without further ado, Alan, why don't you go through what the subpoena power is, that the board has versus everybody else?
Sure. So subpoena power is extremely broad. They can investigate really any licensee when they find that the licensee has engaged in any act or practice declared unlawful, or if they deem it in the public interest to inquire whether such a violation may exist. In other words, if they think that something bad is going on or something bad may be going on, they can begin an investigation. When they do that and they send you a subpoena, kind of as we discussed before, it can be in the form of a written response under oath. That falls into the patient complaint category, but they can compel you to make a different written response in an investigation. They can inspect your premises. They can examine any record or document or anything prepared or maintained by the licensee in the course of practice. They can require a licensee to undergo some kind of a assessment, either a mental assessment or a skills assessment. It's a very broad power. However, just because it's a very broad power to examine all of these different materials in the context of an investigation of your license doesn't mean they can do whatever they want. As we noted, they can't take any records from you. They can't come in and say, we have a signed subpoena from the Attorney General saying we can seize various things from this office. That's not something that they can do. They can't get an order from the Attorney General allowing them to enter your office without you being there. They're not going to show up, break down the door, search through everything in your office. It has to, while they can, once in the office, essentially search anything that's relevant, they can't just come in whenever they want. They can't show up whenever they want. They don't have the power to do that. So while the subpoenas are very broad in nature in terms of what they can investigate, they're very narrow in scope in terms of the power that the actual investigators really have to do those investigations. And it's important to note that, because the investigators really will not tell you that. They will make it seem like they have the ability to come to your office unannounced and demand you surrender your license. In fact, oftentimes they show up with a consent order for the doctor to sign, surrendering their license, surrendering their CDS prescribing certificate, and essentially voluntarily putting themselves out of practice. They don't have the power to do any of that. If an investigator shows up with those things in their hand, definitely don't sign them. They can't make you stop practicing, even when they tell you that they can. All they can do is ask for records, inspect your office, do anything that's relevant to your licensing or to your license with the state. And that's also distinguished, obviously, from the criminal authorities, who can seize records, who can come with a warrant sworn by a judge, come into your house, search for very specific things, but they can come in whenever they want. So it's really understanding that balance between, what can the criminal authorities do? They have much stronger power, but it's very narrow, and they need a lot of authority or a lot of permission to do it. Whereas the board really has a very low threshold to begin an investigation, can do a very wide investigation, but has very limited power in terms of how they can actually gather evidence, how they can actually come to you and search your office or whatever it may be.
And that's a key issue, Alan, because the criminal and civil subpoenas, they can be more punitive depending on what they obtain, the potential risk involved. It could impact you either financially or your freedom if it's a criminal investigation. But that's why those subpoenas have more strict guidelines. You have to follow the rules of evidence, rules of civil procedure, and subpoenas in those cases are never due that same day. So those subpoenas will have a return by date. You can quash those subpoenas in court. So there's a lot more that you can do in that context. One thing that we've touched upon here and there is, what are the limits of investigators? What can and can't they do? And one of the things is, yes, they can show up with a subpoena. Yes, they can show up unannounced and investigate your office. But they can't, no matter what paperwork they have, require you or your staff to submit to an interview or provide any investigators on the spot. They may have a request for an interview. They might even give you a PEC notice hearing, where they're saying you're going to show up in a month. But whatever they give you, you don't have to talk to them, and you shouldn't talk to them that day. You shouldn't talk to them until you retain counsel. Counsel can be present for a lot of these statements. We did that very recently for a client of ours. They showed up to the practice unannounced. We called the deputy attorney general. We set some ground rules for the inspection. They inspected the premises. They didn't take any statements. They came back a week later. We were present for the statement. We had a week to prepare the client for the type of questions they were going to ask. And after the fact, we sort of downloaded all the information and figured, we should probably do a post-interview submission to the board. And we did that to sort of, again, cover any potential areas that we missed during that interview, which can be a stressful process. So there is a cadence to this. There's a process that we can follow. So it's not too overbearing for you, and it's not something that you should be scared of. You have to speak to an investigator, but it's always better to be prepared, whether it's a deposition, a hearing, a statement. The more you talk to an attorney and they prep you for the questions and you anticipate the questions and you have an answer ready, the more you demystify it, the less stressed you're going to be, the more natural your answers are going to be, and the less likely you are to say something that might get misinterpreted. Alan, if you want to talk about the next couple of points, because those come up a lot with our clients.
Right. So most importantly, an investigator can't arrest you or get a warrant. They have no power to arrest you or to stop you from practicing or to impede your ability to do anything other than just to, have to show up and have to respond to whatever subpoena or inspection demand that they show up with. This is important because some investigators believe that they either should have the ability to arrest you or do have some kind of modified regulatory authority to do something to you, and they will express that to you. And if they do, just know it's not true. Just know that some investigators believe that the best way to get what they want out of a physician is by misleading them or intimidating them. They can't get a warrant either. In that same vein, they can't go to a judge, swear out a warrant, go before them and say, well, I have probable cause to search for, X, Y, and Z. They don't have that power. We've had this happen, more the warrant than the threatening to arrest situation, but we've had this happen to a number of our clients. I've seen it happen when I was a prosecutor, where some investigators kind of lead by doing whatever they want because they have a certain goal in mind when they go to a doctor's office, and will say whatever they can say to get whatever they want out of that doctor. And they really can only come to your office and do whatever it is that they have a signed piece of paper saying that they can do when they're there. Also, it's really important to note, and people don't really realize this, especially when an investigator shows up to talk to different people in their office. Any unlicensed staff you have, if you have front office managers, if you have people that work at the front desk, if you have people that provide a variety of different services in your office, but they're not licensed with the state in any way, they don't have to talk to the investigators. The investigators have no power over them, have no ability to compel them to talk, and they can't take it out on you as a failure under your duty to cooperate if your unlicensed staff refuses to talk to them. So if investigators ever do show up and start asking to talk to everybody there as witnesses, while they can make any physician's assistants or nurse practitioners or phlebotomists or whoever else is licensed with the state, they can make them talk to the investigator, they can't make anybody who's unlicensed talk. So just, you can always bifurcate those two groups of people and just let them know that. They have no authority over you when an investigation is over. This doesn't typically come up, but sometimes certain investigators may have a vendetta against a certain provider, even after a consent order has been entered in with the board, ending that investigation, or the whatever allegations that they had against the doctor are dismissed for whatever reason. Sometimes a investigator will continue to harass you. If that happens, you obviously want to call your counsel, because you can file a complaint with the Attorney General's office or something like that. But if they do not come with a signed subpoena, signed demand to inspect your office, something like that, they have no authority over you to do anything, especially once an investigation is ended. So this last one is really in the context of when I discussed earlier how sometimes an investigator will show up in addition with a subpoena, a demand to inspect your office. They'll show up with pre-written consent orders, which are basically settlement agreements with the board that are a temporary surrender of your license to practice medicine, a temporary surrender of your CDS privileges. And they'll tell you, you're under investigation while things are really hot right now, and while we're really investigating this, you should surrender your license. It'll make everything go easier. And then once we've finished our investigation, this temporary suspension will be over. These investigations can go on for years sometimes. We had a case that started in 2019 that is still under investigation currently. And if that person had surrendered their license in 2019, they would have been out of practice for 4 years for no reason. It's very hard to get your license back once you have surrendered it. Even in those circumstances where you negotiate a settlement with the board and there's a time limit on it, it's much easier to get your license back, but you still have to go through some hoops that you may not understand when you're signing that. But certainly, if an investigator is pressuring you into signing over your your ability to practice medicine in the state of New Jersey, even when they tell you it's temporary, temporary can be forever, because they really have no impetus to do anything to get you your license or your CDS back in your hands. And one other thing to keep a note of is if you ever have an investigator come to you and say, well, it would be better for you to surrender your license right now. That's never true. That they'll say that as a way to make it sound like they're going to do you some favors, or it'll make you look more favorable to the to the attorney or something like that. It's never true. There may be circumstances where surrendering your license after being contacted by the Deputy Attorney General may make sense on a temporary basis, but even that, there's no power for them to make you hand over your license. If they want to do that, you're going to be showing up before the Board of Medical Examiners on a order to show cause. So really, just if you can remember anything from this, it's don't ever hand over your license to practice medicine to an investigator.
Yeah, and we see that happen very often, where we will get involved in a case after they've given up their consent, after they sign a consent order, a temporary consent order, interim consent order. It doesn't matter what type of consent order, what the verbiage is. There's nothing temporary, and just from a pure litigation standpoint, the only thing that these investigators and the board are interested in when they show up to a practice with a consent order is getting your signature. They'll say anything they want to get that signature, anything that they think will influence you to sign that. And that right there is your only leverage with the board to get them to the table, to deal with you fairly, to get them to talk to you. I can't tell you how many times my clients have retained us after surrendering their CDS, for instance, and then the board is very, very slow to get back to us, to schedule a hearing, because they already have what they wanted. So when the one thing that they want you have, that's when you have to leverage it to get them to the table, to listen to you, to talk to you, to try to convince them that they're after the wrong party. And if there was a mistake, to at least leverage it to negotiate the best possible resolution for yourself. Common misconceptions. This is, very important here. So investigators do not have a duty to tell you the truth. That is in stark contrast to your duty to be honest and forthright with investigators. You can't mislead the board. You can't lie to investigators. But investigators, this also goes for police officers, DEA agents, FBI agents. Anyone who's an investigator does not have to tell you the truth. They can lie to you, and that is considered an investigative technique. That's why they're allowed to do that, but you're not. So if an investigator says you'll get your license back, we just need this temporarily during the pendency of the investigation, that first of all, it's not true, and second of all, they don't have to tell you the truth. Subpoena versus warrant. This has come up a few times. That's why we just have it here. A subpoena, we've talked about it in depth already. It's a request for records, usually with a due date, like give it to us by the end of the month, by 15 days, whatever it may be. A warrant is you have the right to remain silent. And although we're not here to give legal advice today, my advice would be stay silent, get an attorney, because you don't want to start talking. If they have a warrant, that means they've done a lot of legwork before they get there. Investigators never just want to talk to you. They don't want you to help them clear things up. You have to understand where you are in this journey, we'll call it, from the inception of investigation to a decision whether or not to try to either take your license, seek disciplinary action, pursue a criminal or civil case. You are the last stop on that train. That train's last stop, okay? They start talking with your patients, they talk to colleagues, they might talk to staff, they'll review records, they'll review PMP data, they'll do pharmacy logs, They will look at everything. They'll have a picture in mind. They have a story, and now they need you to say something to be able to put it all together, to confirm where their investigation they think has led them. You're the last stop on this train. So don't think that you're there to clear it up like you're having a collegial conversation. This is something that you're the last stop, and that's why you have to lawyer up, because we need to find out as your lawyers why they're talking to you, what they think they need from you, what their conception of you, what their perception of you is. We need to understand that. Cooperation means future consideration. That's never been the case. And by the way, cooperation doesn't mean handing everything the day that the investigators get to your office. Cooperation could simply mean my attorney will get back to you. We'll discuss this further. Or, okay, I got a board response, a board complaint. I'm going to respond to it, but I need additional days, 21 days to get my story together. You don't need to cooperate. You need to do anything right away for consideration. Sometimes cooperating early, just reaching out early helps, but that's a decision you'll make with your attorney. And then another misconception is, well, I can't afford an attorney to represent me in this. This is one where, we have been, pounding the drum here, particularly in New Jersey. You are blessed, believe it or not, to be in New Jersey. Not every state offers this, but the state of New Jersey allows your medical malpractice insurance company to offer as an added benefit or as an additional benefit if you want to get higher premiums. But you will get legal counsel to represent you in board matters and board investigations. This is something, and also in audits from payers. I mean, you have insurance coverage, administrative riders that are built into your medical malpractice policies here in New Jersey. So if you're a New Jersey practice, you absolutely have that coverage. You pay premiums for it. Reach out to them, get covered. Don't spend money, or don't try to do it yourself, trying to do it on the cheap, because you can get representation and have it be paid for out of the premiums that you're paying yourself. Alan, do you want to go over some of these misconceptions about board responses and hearings?
Sure. So one of the most common misconceptions, I'd say probably the most common misconception, is that you don't need to respond to a board complaint because it's clearly frivolous and the board will understand that and they will just throw it away. If you write a letter to the board explaining that it's clearly frivolous, they will always, or I shouldn't say always, but often throw it away. But you need to respond 100% of the time. Whenever they write you a letter, whenever they say, we're reaching out to you and under your duty to cooperate, you need to provide a response. You always need to respond. Even if we had a complaint that accused somebody of being Satan, we had a complaint that accused somebody of being a hitman for the mafia. These are really frivolous complaints. They will throw them away. You need to respond to them with some amount of seriousness to at least rebut those allegations, because it's an administrative body. They need to dot their I's and cross their T's. So that's really the number one common misconception. The complaint is not about me, it's about my staff or billing. What they like to say at the board is, you're captain of the ship, you're the doctor, you're the licensee. If somebody files a complaint against you, it doesn't matter who the allegations are against. If it's filed against you, you need to take it in a way that the complaint is against you, regardless of who they're alleging was the bad actor. Oftentimes, if somebody else was the bad actor and you had nothing to do with it, it will get dismissed, but there still needs to be an investigation done on their part, and you need to respond in some way depending on what type of investigation they're doing. This is also something we see very often, especially when people respond to complaints when they're not represented, where they look at a complaint, the person complained about 5 different things. 1 was serious, 4 were frivolous. They say, well, I'll respond to this one serious thing, and they respond well. And they'll say, well, this other one may be serious, I'll respond to that, and ignore everything else. If you don't respond to everything in a board complaint, the board will essentially accept those allegations for the purposes of adjudicating that complaint as true, and will oftentimes call you in to explain the complaint again before the board, where you'll have to again talk about all these issues. You'll have to talk about all the other issues you didn't talk about before. You'll have to waste half of your day at least going down to Trenton or doing it on WebEx. I don't believe they're doing any in person still. But you still have to waste about 2 hours talking about all of these frivolous complaints to the board. So it's very important that when you respond to the board, you respond to everything, regardless of how you personally think of the complaints that are listed. I'm too busy to deal with this. You're never too busy to deal with this. I understand how busy you are, but this is one of the bodies in the state of New Jersey that can literally take your license away if you decide that you're too important to deal with them. They have complete control over your license, and that duty to cooperate does give them disciplinary power that they can exercise very broadly. And I'm sure we'll just touch on this in another webinar, but when you have discipline in one state, every other state gets notified. Every other state is going to take its own reciprocal action depending on the allegation. So even if you think, well, it's just New Jersey, I don't practice there, it doesn't matter. If you practice in New York will find out immediately, and they will start asking questions and want to take their own discipline. I can send in records without any explanation. The board will get it. This isn't true, and it's just a bad idea. Whenever you send in your own explanation, you have the chance to frame the issues and explain anything that may fall through the cracks that somebody wouldn't notice if they just read your record. So you should never think you can just send in an explanation, and actually you should take any chance you have to explain anything to the board as kind of a gift to use that opportunity to really put everything in the best light possible if there is a patient complaint. I'll just throw myself at the mercy of the board. That is a very bad idea. I don't know how to say it other than that. The board is not very merciful unless they really, really like you. But even in that case, if you just say, well, I can't defend these allegations, please don't go too hard on me. They may put you at the lower end of whatever the discipline range is, but it'll be the lower end, and they will still take some action unless you put up some kind of a strong defense. I don't need a lawyer for this hearing. I can talk to the board doctor to doctor. That's something a lot of people who go in unrepresented believe. The problem is, these doctors are also state agents. They act on behalf of the state. They act in the best interests of the state. So even though you're talking to them doctor to doctor, they're looking at this from a public safety perspective, and they're not going to simply say, all right, well, I scratch your back, you scratch mine, we look after each other. They will do that, but not if you think you can go in there doctor to doctor, more if you can convince them that, this is something that isn't really an issue. It's something that, is kind of a professional, in the professional context, it's okay. And the other problem a lot of people have when they don't go attend with a lawyer is they show up unprepared. They show up not understanding what the issues are. They show up believing they can just kind of hand wave away the allegations because they're not really a big deal. Those are all problems because the board's going to notice that you're not taking it seriously, and that's really where they will up the ante. It's not about showing up with a lawyer. It's about showing up unprepared, but often people who don't use a lawyer don't prepare properly, and that ends up putting them in more hot water where they need a lawyer even more, and it becomes much more difficult. And the only other thing I would note is, with the attorneys, is it also makes any kind of discussion with the deputy's attorney general more simple and straightforward. The deputy attorneys general really operate under the assumption that the doctors don't know any of the rules and will try and take advantage of them. Not in the same way the investigators will, because they're bound to different ethical canons, but they will press their advantage in that context too.
Yeah, that's a good point. Yeah, just to put a bow on that, we usually tell our clients we make, we earn our keep in the way we prepare you, and we've had more than one client go before a PEC hearing and then afterwards say of our prep session, you guys were harder on me than the board. And we like to hear that, because if we beat you up enough that you're thoroughly prepared for the board, like a deposition in a med mal suit or any other type of hearing, the more prepared you are, the less anxious you're going to be, the better you're going to come across. And we understand the regulations that they're going to be questioning you on and how your answers need to be crafted so that they're not misinterpreted. Attorneys don't tell you what to say. We help you communicate what you did in a way that makes sense. We don't tell you what to say. We just kind of tell you how to say the things that you're trying to say so that you don't misspeak. Because if you misspeak and it's written down in a transcript, it's going to look like you understood the question, you answered that question knowingly, and now they can take affirmative action against you based on that. So in conclusion, we don't want to run too far over. This is just our, like I said before, our effort to demystify this process, and the next couple will be a little more of a deep dive into how to deal with specific aspects of it and what the consequences are. But just to conclude this, you do have a duty to cooperate with the board, but that doesn't give them carte blanche to do whatever they want. This is a lot of times why you get attorneys involved, to sort of pump the brakes and set some ground rules. The board and its investigators, they have broad investigative powers, but again, they're not unlimited. So, it's right for you to question their authority at times and get counsel involved. And please never overlook a board complaint or an investigation or a hearing, like we were just talking about. They all can potentially impact your license or limit your ability to practice. The board is very keen on letting you practice, but now you can't prescribe any scheduled drugs. But what does that do then to your hospital privileges? What does that do to your nursing home privileges? Do you have board certifications that require you to have an unfettered, unrestricted license? You could lose your board certification. So there's a lot that needs to be taken into account beyond just reciprocal actions from other states where you're licensed. There's a lot of people that get these notifications from the National Practitioner Data Bank about a licensure limitation that will take their own action against you. So this is part of what we do when we counsel our clients. We want to thank you. I don't know if we have any questions at this time from the Q&A, but if you have any questions, or if you're going through a board matter and you are unrepresented and you want our assistance, or you have any other issues that you want to discuss with us, please feel free to reach out to myself or Alan. Our information is here on the slide. You'll get a copy of this of the slides. You get a copy of the video of this presentation in the future, and we look forward to seeing you at our next two presentations. Thank you so much.
Thank you, everybody.